Good day, liberators and fellow citizens of the world. I've said this many times, that AfriForum is not our friend, especially not the friend of the so-called Boer or Afrikaner, Afrikaans-speaking white people. If you think that AfriForum is there to protect your rights, think again. I'm going to show you again that they cannot be trusted and that they are just thinking about themselves. They went to America because they wanted to get funding for themselves. They did not care one bit of protecting your rights. I'm just flabbergasted each and every time when white people are making waves, or they get aggressive, or they get very angry because of certain things that happen. Julius Malema singing kill the Boer, kill the farmer, and now it's apparently all right. Let me give you the real facts. And as I've said before, and people know us, if you think that we are the deceivers, please challenge us to a live debate on a podcast of your own choice. Challenge me to answer your questions and to answer to the proof that you have got that we are the ones. I am the one deceiving the people. Up till now, I have never been. I've been challenged once. Many people have said that they're going to challenge me, but they've disappeared. But once it did happen, and it turned out that it wasn't the case that we've deceived or that we could not be trusted. So let me just show you the truth of what is going on with the so-called legality of singing "Kill the Boer, Kill the Farmer" song, liberation song. The one who is deceiving us is in fact AfriForum. And I'm going to show you the proof in the court documents, in the judgments, dating back to 2011. And many of you don't remember this, but in 2011, AfriForum did exactly what they did with Julius Malema now, but when he did to him when he was still the leader of the Youth League, ANC Youth League. So in 2012, the AfriForum took Julius Malema and the ANC to court, Equality Court again, for chanting that infamous song. And during that occasion, let me show you the proof before you say that I'm the one deceiving you. But let's rewind back to 2011. Now, way back in 2011, this court case, it was in the Equality Court in the High Court, sitting at the Johannesburg High Court. Case 209-68 of 2010. I will publish this and give you the reference so that you can go and read this yourself. Now, what has happened? The court in that instance have dissected the entire singing of it and the occasions and everything. And in that court case, AfriForum was successful in obtaining an order against Julius Malema, Mr. Strawberry Hat himself, and the ANC. And in this case, let me go to the order. It was declared that constitute hate speech there, and then the words and the song constitute hate speech. That was a declaration by the Equality Court, a Judge Lamont that was sitting there. But this case went on appeal, and that is where the whole thing got very strange. On appeal, the ANC and Julius Malema appealed that, went to the Supreme Court of Appeal on appeal, and shortly before the appeal was heard, apparently by direction of the Supreme Court of Appeal themselves or itself, the parties entered into negotiation, into settlement agreements, and then something strange happened. There was a settlement reached, and AfriForum withdrew and basically abandoned the order that they got. Now, what is important here is that AfriForum took that case to the Equality Court in public interest. So they basically were the representatives of the people who are being prejudiced by the singing of the song. So if ever you think that you are one falling within the group that's going to be that hate speech is going to be directed at you, then they took the case to court for you. Okay. Now, what's important is that in this court case, and please go and read, I'll put the reference up, everything, you can go and read it. The court basically said that no one knew about the song or what it actually means. It has been sung for years, but then the media suddenly picked up on an occasion where it was sung, and then the journalist there, the writer of that article, started to push the narrative that it's discriminatory and hate speech, and then AfriForum jumped on the bandwagon. So the situation was, or the problem was created, and then suddenly AfriForum pitched up with a solution, and they took the matter to court. Okay, now very, very nice. They went through a very intensive court case, and go and read that. It's a very interesting court read. Go and do that. But interestingly, the fact that they suddenly just abandoned it. But at that point in time, we never knew why, because it just disappeared. The media stopped reporting about it, and we just thought, okay, you may not sing it. That was that we believed. Okay, but to a long story short, then recently the narratives are being pushed, the false, deceiving narratives, as I've reported in my other videos and made extensive videos about it, that the Expropriation Act, Kali Kriel and the Roots and everyone went to America to beg Donald Trump and Elon Musk to please assist the atrocities against the white people in South Africa, and there's a genocide going on. We are being slaughtered left, right, and center, and now the Expropriation Act is going to take our farms and our property and all bullshit. But in any case, now what has happened is that in this court case, now the Constitutional Court allegedly made a ruling to say that it is acceptable that this song may be sung. Okay, but that's not what the Constitutional Court said. The Constitutional Court basically, only in a one sentence, as they always do, yes, we all have challenged that practice of the Constitutional Court to the African Union, and we have received and awaiting our decision on the merits of that matter. But irrespective, the Constitutional Court allegedly, a full bench of 8 to 9 judges have decided that there's no prospect of success in an appeal. Now that does not constitute that the Constitutional Court confirmed that you may sing this infamous song. It merely stated that there's no prospect of success. So they have identified the entire case and in its entirety, and they've concluded that they would not come to a different conclusion than the Supreme Court of Appeal has. And the Supreme Court of Appeal judgment is the one that you will find the actual reasons. Let's go to that interesting court case. Let me first go to the original case that was in Johannesburg that AfriForum appealed to the Supreme Court of Appeal. But what is important here is that Mr. Roots, the CEO of AfriForum, considered himself as an expert witness because he wrote the book on Kill the Boer, Kill the Farmer. And that is what actually flushed out the entire case for AfriForum. Because the intensity that they have approached the case way back in 2011 versus what they have done now is questionable. They've taken slobbish bypass and they've put in arguments that's totally different than the ones they've presented way back in 2011. Now, in this case, Mr. Roots was the expert witness, and the court found here that the expert witness of the complainant found not to qualify as an expert witness because he is employed by the complainant and has a vested interest in the outcome of the case. So as I say, the left hook uppercut of AfriForum was the expert witness, which was Mr. Roots himself, which has been disqualified. So the actual one that must present the case and must prove the case beyond on a balance of probabilities, Mr. AfriForum, they've screwed up their case. They screwed it up. They could not present enough evidence to justify the order that they wanted. So then they went to the Supreme Court of Appeal, and there it gets very interesting because firstly, I'm going to go to the point in limine which was raised by Julius Malema, and here Julius Malema said that the EFF raises a point in limine against AfriForum's hate speech complaint based on res judicata, more accurately issue estoppel. they're trying to mix two legal principles, res judicata, which means that the case has already been judged, with estoppel. Estoppel is basically when you assume that you do not have any issue and someone else reacts to it, then and then suddenly afterwards the other person say, oh yeah, but I did not give you permission, but your whole approach was that you're fine with it. Then you can raise the doctrine of estoppel as a defense in law, but they're trying to put the two together, which I found very much difficult in the way that it was explained, but that's not the point. I want to get to the agreement that was reached way back in 2012 when the first matter had to go on appeal. So in this case, as in the complaint before us on appeal, the first complaint was also directed at Mr. Malema's singing of the Bulu Ubuni. At the time, Mr. Malema was a member of the ANC and he sang the song in public, blah, 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 blah. Now, what is declared here? That this paragraph is very important. And yes, people, I do not always agree with judgments, especially that judgments can be written in a way to push the narrative of the court. It's basically when you, I explained it with, if you wear yellow glasses, spectacles, and you stand on a bridge over the N1 highway, you will, and you look down, you will only see yellow cars. So in this instance, yes, judgments are being written in a direction, ignoring these the counter arguments in many respects, but I do not see that this is a case of such a judgment. This does appear like a somewhat legitimate no fault judgment, because it records specifically what the AfriForum did and its CEO. But let me just explain to you this. The Equality Court upheld the first complaint. It declared that the singing of the song constituted hate speech and granted an interdict against the ANC and Mr. Malema singing the song at any public or private meeting conducted by them. That is what I've confirmed the 2011 court judgment. The matter came on appeal to this court and was enrolled for hearing on 1 November 2012. At the suggestion of the president of this court, the parties engaged in mediation process. So the president said that please try and mediate this. This resulted in a mediation agreement entered into and signed by AfriForum and Mr. Malema. An order was made by this court on the 1st of November 2012 under case A815/2011, the settlement order. Now this is what the settlement says, and please people, read this, go and read this carefully, because this is totally different from what AfriForum is trying to explain to you and get your support so that they can go to Trump and Musk to get money, so to fight for the not singing of this evil song anymore. Okay, now the terms of the settlement order recorded that it was in full and final settlement of the dispute between the parties. The parties agree that it was crucial to mutually recognize and respect the right of all communities to celebrate and protect their cultural heritage and freedom. To this end, they committed to deepening dialogue among leaders and supporters of their respective organizations to contribute to developing a future common South African heritage. Remember that AfriForum is conducting this case in the interest of the public, and specifically those people or those communities who feel prejudiced by the claimed hate speech of this song. Okay, now it goes on. They recognize that certain words in certain struggle songs may be experienced as hurtful by members of minority communities. And then D, the ANC and Mr. Malema recognize that the lyrics of certain songs are often inspired by circumstances of a particular historical period of struggle, which in certain instances may no longer be applicable. In the interest of promoting reconciliation and avoiding inter-community friction, they committed to counseling and encouraging their respective leadership and supporters to act with restraint to avoid the experience of such hurt. And then E, AfriForum agreed to abandon its Equality Court order, and the ANC and Mr. Malema agreed to abandon their appeal to this court. There you've got the settlement agreement. Now, isn't that totally different from what they've suggested in the judgment of 2011 in the first instance? So clearly, according to me, money was most probably pushed under the table to AfriForum. That's why they've made this. But irrespective, this is not an isolated incident. Another aspect came up in this whole entire case, where and I will show you this just now, because what I just quickly want to reiterate here is why the Supreme Court of Appeal dismissed the appeal of AfriForum. This is number one. It says that Mr. Roots was the main witness for AfriForum. He described him as an expert witness, although the Equality Court rejected his status as an expert. AfriForum took issue with this finding in its grounds of appeal, but nothing turned on the point. Okay, because they haven't pursued that, basically, and they haven't made an issue of that specific matter. Mr. Roots' evidence was based on his book, Kill the Boer. He described it as a current affairs book about the phenomena of farm attacks, blah, blah, blah. So Mr. Roots, the CEO, basically wrote a book, and based on the fact that he wrote the book, he basically claimed expert witness to be an expert witness. But any legal practitioner with the slightest knowledge of litigation will know that you cannot use an expert in your own team to be an expert. You must get an independent outside person to address that, because Mr. Roots had an interest in the outcome of that case. So he could never have been utilized as an expert, a logic thing for any legal practitioner with basic knowledge of the law. So why did they do that? I say that this case was deliberately done. It was intentionally pushed because they wanted to create a narrative, they wanted to create a problem, and then they would come up with a solution. And the solution is to go to Mr. Trump and Elon Musk to find money for their organization to do whatever they want to do. Okay, let me read further. Before this court, AfriForum took the view that the overwhelming bulk of the evidence led in the Equality Court was irrelevant to the appeal. The only parts of its own evidence that AfriForum maintained were relevant were Mr. Roots' testimony and that of Mr. Prinsloo and Ms. Human, and only to the extent that this evidence affirmed the social milieu in which the words were used and the impact. So, in this case, besides Mr. Roots, they only had two other experts. They did not put in much effort like they did in the 2011 case at all. This was just a quick come together, let's go to court and put everything that we can quickly together to make some case or appear as if this was a legitimate challenge, and let's go to court. This was totally slobberig. This is a clear case where that should tell or show students in law how not to present your litigation case, not to do it. But in any case, they did it. Now, further, in paragraph 78, very important, they've changed their argument from what it used to be in the Equality Court in Johannesburg. Now suddenly on appeal, they came up with a total different story and different relief that they want. In paragraph 78 of this court case, it was clear that this was not the case made out by AfriForum in the Equality Court. And in paragraph 72, at the hearing of the appeal, counsel for AfriForum accepted that the amended relief was too wide, and that if the appeal was to succeed, any declaration that the songs constituted hate speech would have to be expressly limited. And then it goes on, in light of the concession, this is the most important part of this entire judgment, according to me, of the Supreme Court of Appeal. In light of the and when I read this, please, those of you who are supporters of AfriForum, please let this slip in. This is what AfriForum actually wanted. So the story that they are pushing in the media is totally, it's bull. It's not the truth. In light of the concession, it is important to appreciate that the appeal is not about an outright ban on Tubuli as hate speech per se. The question is narrower than this. It is whether when Mr. Malema sang or led the singing of the song on the occasions identified by AfriForum in its complaint, this constituted a form of hate speech as framed by AfriForum in its complaint. Similarly, Dr. Ndlozi's singing of Shisha Lamabunu in Senegal is the focus of the inquiry. So they did not ask the court that this particular song is hate speech. Remember that the court already declared it as hate speech in 2011, but AfriForum abandoned that order, so effectively that judgment has become null and void. Now in this case, they've changed their tune. Now they're just saying that Julius Malema may not sing, or the singing of that song on those occasions were hate speech. So effectively, they could not have convinced the court that on those occasions it was considered as hate speech. Hence why, at the end of the day, this fell through the cracks. The Supreme Court of Appeal confirmed that the judgment or the order of dismissing that the complaint before the Equality Court in Johannesburg was correct on the facts presented to them by AfriForum. So, and let me put a final nail in the coffin. The issue about the old South African flag, those of you are very passionate about keeping the flag, etc. If you really, according to me, if you really want to, go ahead and do it. If you feel free to do it. But at the end of the day, what Kali, Mr. Roots said. Let me just get to that point. That Kali Kriel. Oh yes, Kali Kriel. This is the court case that broke the back of the old flag. That we are prevented from displaying the old South African flag in public anymore. Also a case by AfriForum, and they totally screwed it up. So I'm not saying that I support the issue of showing the flag. I'm just saying that, you know what, we have reached a point in our lives and in our history that those things like singing liberation songs and holding the old South African flag should not matter anymore. We should be at a point whereby we know that it happened in the past, just like Hitler was in the past. Let him stay in the past. But the fact of the matter is that, and yeah, maybe it's a wrong example that I've used with Hitler, and please do not crucify me because I've mentioned his name. It was just an example. But the fact is that these things should not regulate our daily lives anymore. We should embrace as citizens of all races and religion in South Africa, not to go ahead on the color of our skin or the sex we are or our sexuality or so forth. We should be treated equally as co-citizens, and that's that. But this is what Kali Kriel in an affidavit said, people. Let this sink in. That question led to a debate on national television and radio between Mr. Atang and Mr. Kali Kriel, the CEO of AfriForum. Mr. Kriel surprisingly denied that the old flag had been displayed at any of the protests, dismissed the reports about such displays as fake news, and subsequently published statements on Twitter to that effect. AfriForum, he said, discouraged its members from bringing the old flag to public gatherings, which detracted from the main message, which on Black Monday was the issue of farm murders. Mr. Kriel stated that although it was unwise to display the old flag as it would offend people, it should not be unlawful as it is part of history and you cannot ban history. Okay, so that is what stated, but very importantly, this is what Kali Kriel, the wonderful Kali Kriel that also went overseas to Trump to fight for minority rights. This is what he said. AfriForum's response to the claim that gracious displays of the old flag constitute hate speech was that the relief sought was a wide-reaching ban. Mr. Ernest Roots, its deputy CEO, who made the answering affidavit, went on to say this. At the outset, we acknowledge that the old South African flag has the capacity to cause offense and emotional distress. As an organization, we have no particular love for the flag or what it represents. In the exceptionally rare instance that anyone participating in one of our events bringing an old flag with them, we ask them to put it away. So all of you Boers and white Afrikaners and so forth, which is also my tribe or considered to be my tribe, this is what AfriForum is saying in an affidavit about your supposed flag that you love from the past. So they've closed the door already for your heritage and your liberation struggle, etc., to just disappear. So they've caused it. In this case, they fought against that. Although they said, okay, but there should not be a general ban on it, blah, blah. But they've destroyed the argument. So that is why we are not allowed to have the old flag displayed in public anymore because of this. So where you go out today and plan to make a deposit into the account of AfriForum to protect your rights, think again. Number one, they most probably got a lot of funding from America now because they they have pushed this narrative of that the white people in South Africa are being slaughtered and land will be taken left, right, and center, which are all bullshit, plainly. Now, at the end of the day, this morning I got this email, and I just want to. This is an email from Daily Maverick. It's the headline this morning. How to normalize ethnic cleansing with the help of false binaries, AfriForum and anti-Semites. And this is exactly why this is also happening. And I will just show you what has now happened thanks to Kali Kriel, Roots and all the clan. Now it's said that in this horrific context by Daily Maverick's reckoning, the cultivation of AfriForum by the world's most sophisticated Zionists was a stroke of formidably cynical genius, because not only had Roots, a former deputy CEO of AfriForum, been skillfully played by Shapiro, Kali Kriel, the current CEO, had been skillfully played by Joel Pollak. He said, Israel should take South Africa to the International Court of Justice. Pollak, editor-at-large of the US far-right Breitbart News, had tweeted on 28th of March. Kill the Boer and phrases that accompany it, such as kill the farmer and shoot the kill, are clear incitement to genocide. From the context that AfriForum has now said, oh, shucks people, everyone may sing kill the Boer, kill the farmer, it's just not on. Our rights are being prejudiced because we may not have the old flag, but they are allowed to sing kill the Boer, kill. That's not what the court ruling said. The court ruling initially said that it's not allowed, but AfriForum made it relevant because of what they have done. People, AfriForum is not our friend. Wherever they pop up, they're always in synchronization between themselves and Mr. Strawberry Hat Julius Malema. They can't, when this one is saying, then the other one pops up. When that one says something, then the other one pops up. They're always in synchronization with one another because they are being funded by the same people. The same ones that pushes the EFF, or who had pushed the EFF, has also been pushing AfriForum. Let that sink in for you. Hopefully, this gives you a much better input in the current affairs. And please do not misrepresent me. I'm not saying that go out and it's fine to sing kill the Boer, kill the farmer. The fact is that, number one, we never knew that it was a hate speech song, allegedly. It was made relevant by none other by AfriForum and Julius Malema, who's in synchronization with one another. Secondly, what does it matter, really? If someone goes and, I say this, that put it in this perspective, and this is basically also what the Supreme Court of Appeal said, as I can understand it, and I relate it in much easier terms to you. Say, for example, there was a movie in 1970 where there were jokes made of, for example, a black gay man. Okay. Now, under those times, those instances, it was accepted. There wasn't actually much made about it. But when you would have made that movie today, and it's not for educational purposes or for research purposes, then such a movie would have been, if created today, would be seen as hate speech, discrimination, a no-go. It will not be made. But if you go today and find it on the internet and you go and watch 1970, that movie, and you watch it today, will that make you someone who's discriminating against black gay men? Or is it something that it's there, it's part of history, it has been made, and you cannot just go out and terminate and destroy all the movies of that nature that were made? So the court basically said that it's a song, it was made during those struggle years, you cannot wish it away. So if it's sung, it has to be sung in today's context of unifying us. And not the moment when you use, and that is what the first 2011 case said, the moment when you go out and you use that song within the context as it was in those days, as if it is still relevant today, and you are saying that go out and fight against white Boer farmers, then that would constitute. But AfriForum has failed to prove that in their case. That's why their cases were dismissed. So it's not that we should. That's why I'm also saying that something that we have to look at is the old South African flag. Also a matter that was pursued by AfriForum. I'm very much tempted to say that there's a possibility that that could have been argued in such a way that the old South African flag within context of today would have been allowed. But now it does appear as if it's a total no-go, may not display it in public, you may not even hang it on the post in front of your home anymore. So let this sink in, and hopefully this has explained to you in a much better way than the vagueness in the media and on social media. Take care until the next day. God bless.
Liberty Fighters Network.
Liberty Fighters Network.